morning, Senators, Mr. Speaker, sir. My name is Peter Wanyama. I will be making submissions regarding a very fundamental point, which touches on these proceedings, the constitutionality and legality of these proceedings. Mr. Speaker, sir, we have a problem. These proceedings we submit in terms of compliance with the Constitution, the provisions of the County Government Act, and your own standing orders are a nullity in law. Nullity in the sense that there are certain legal questions which then lead to the conclusion that if those legal questions are considered, then in your decision when you are retiring to make the final vote on the charges facing the governor, you must address that question first. And the question is on the question of timelines. It is, I know, difficult for you yourselves to make this decision because the illegality in question arises from a decision of the Senate itself in these impeachment proceedings, and not an illegality that arises from the County Assembly proceedings. So as I said, it's a very difficult decision to make. In court, it's very easy for us to make submissions for judges to recuse themselves when they don't have jurisdiction. So we are only repeating it here, but now the forum is different. Now, Article 189 of the Constitution, 181 of the Constitution is express, clear, and unequivocal that the process of impeachment of a governor in accordance with the grounds laid in Article 181 of the Constitution shall be in accordance with the legislation enacted by Parliament. And the legislation in question is the County Government Act. The import of that is that the timelines which have been set in the County Government Act derive its validity from the Constitution itself. A response can be made that these timelines can be cured by the provisions of Article 159 of the Constitution, which provides that procedural technicalities are not supposed to impede access to justice. But our submission is that compliance with the provisions of the County Government Act is a constitutional imperative, is a constitutional command. The authority derives strictly from the Constitution, and therefore it can't be cured in any interpretation whatsoever. So in terms of that issue, it is important to emphasize that the Senate has no powers whatsoever to change provisions which have been put in statute. The only power that you have is to introduce an amendment to that section, which shall then go through the normal legislative process, and then the timelines will definitely change. So as it is, I'm going to make submissions that compliance with these timelines is strictly a fundamental legal question, and the Senate, if you look at the provisions of the Section 33 regarding the timelines, in summary, the Senate has breached these timelines by 28 days. The Senate has convened a meeting, a session to hear and discuss the charges against the governor outside the statutory timelines which have been provided for in Section 33 of the County Government Act. And that is very, very, very critical. You are late by 28 days. The import of that is that you have no jurisdiction whatsoever then to consider the allegations which were leveled by the County Assembly against the governor. An additional question. Does the Senate have powers to extend these timelines? Do you have statutory discretion Because normally if timelines have been cast in statute, and you read the statute in terms of interpretation, you will definitely find that some statutes can confer you with discretion to extend these timelines. So the logical question there is, do you have a constitutional or a statutory discretion to extend timelines by interpretation of the standing orders or by a ruling of the Speaker? My submission is that Section 33 has been cast in stone. Section 33 of the county government has been cast in stone, and it doesn't give the Senate in terms of discretion whatsoever. I submit that discretion in this case has been taken away. And in law, we usually say that discretion is like the hole in the donut. Discretion must be exercised within the confines of the parameters of law. If the law has given you discretion, then just like the donut, you must exercise within that confines. Otherwise, any decision that we make which is outside that hole in the donut is a decision which we submit is ex facie illegal. It is unconstitutional and cannot be sustained at all. And I want to also emphasize in terms of decisions which have been made by this House. Remember, Mr. Speaker, sir, this is a House of President. There have been more than seven impeachment proceedings which have been conducted in this House. At no point in time during the impeachment of Governor Wambora did the Senate extend these timelines beyond the provisions of Section 33 of the County Government Act. In fact, during the impeachment of Governor Wambora, the Senate had to sit up to 4 a.m. in the morning to comply with the strict timelines in statute. So that is very, very significant. During the impeachment of Governor Chepkwony, this House had to be called on recess, to hear an important matter concerning the removal of Governor Chepkwony. During the impeachment of Governor Mwangi Wairia, timelines were strictly complied with. Section 33 of the county government strictly complied. There was no deviation whatsoever, even by a minute. During the impeachment of the late Governor Gachagua, again, timelines were complied with. During the impeachment of Governor Samboja, again, timelines were complied with. During the impeachment of the Deputy Governor of Machakos, timelines were complied with. Now, it begs a fundamental question, a very serious question, which we can't run away from. Should Governor Waititu be subjected to a different impeachment test, a different impeachment threshold? What does it say about proceedings which are conducted in this House? What does it say about precedent, the rules regarding precedent which are binding to this House? What does it say about compliance with the Constitution on one fundamental question, which is the principle of equality before the law, which is a constitutional imperative, is a constitutional command, and let me just read it for the record and for the Hansard. Article 26 of the Constitution says, every person is equal before the law and has the right to equal protection and equal benefit of the law. Now, an impeachment proceedings which is being conducted in accordance with the provisions of Section 33 of the County Government Act, pursuant to the provisions of Article 181 of the Constitution, must be uniform. Every governor or deputy governor who comes before this House in an impeachment proceeding must be subjected to a similar standard of impeachment. Any deviation from that then calls into question then the legality of the process. So you can see that it is clear beyond peradventure that Governor Waititu cannot be subjected to an impeachment proceedings which is done at the discretion of the Senate and outside the provisions of Section 33 of the County Government Act. So we can run away from that issue, but it's a live legal question. The courts have ruled on the question regarding equality before the law. Every person must be subjected to a similar treatment and must derive benefit from the law. So why should Governor Waititu be subjected to a process of impeachment which is done 28 days after the titled timelines? Isn't that a problem? So, Mr. Speaker, sir, I submit that we have a heavy and fundamental legal problem which can be cured by the provisions of Article 159 of the Constitution. Another comparison is very, very important. Another comparison. There are strict timelines in Article 144 of the Constitution regarding the impeachment of President and Deputy President. Those timelines must be followed. There's no way during the impeachment of a president or deputy president you can go ahead and change those timelines because they are cast in law. They are cast in stone. They can't be deviated from. Changing those timelines, then it becomes a problem. So in terms of the interpretation of the law, we must interpret the law in a manner that we create a multiple basis for consistency in parliamentary decision making. So in this case, all we are asking for is consistency in parliamentary decision making. So there must be a multiple basis through which we exercise that power to interpret the law. So when you retire, that should be the first and foremost issue. Sorry, first and foremost is in proper English. It should be the first issue for this House to consider. It should rank first in time. The moment you discover that Mr. Speaker made a mistake by convening this House 28 days after the statutory timelines, that is the moment that then you vote and say, we can't allow an illegality. Because the moment you allow that illegality, you are setting a dangerous precedent in the application of that particular section in this country's legal history. The other comparison, election petitions in law are strictly conducted within the timelines which have been set. Just a comparison. There's no way you can extend the timelines which have been put by statute in terms of election petitions determination. Those timelines have been set, again, pursuant to a constitutional process and implemented by statute. And there are policy reasons why those timelines have been cast in that manner. There are policy reasons why it is important and critical that impeachment proceedings against a governor be determined within the statutory timelines provided for in Section 33 of the County Government Act. Remember that a governor is elected by the people, and therefore, Article 38(3) of the Constitution, the governor has a right to hold office. The governor has a right to hold that office once elected. It's a right in the Bill of Rights. And therefore, to take away that right, there can be no substantive impropriety in the process of taking away the governor's right to hold office through an impeachment proceedings. And this taking away, this technicality we submit is substantive. It is not merely a procedural question, which, as I submitted earlier, can be cured by the provisions of Article 159 of the Constitution, or a ruling of the Speaker varying the standing one. So we submit that the Honorable Speaker made a substantive and a fundamental mistake, a serious mistake, which casts doubt to the legality of these proceedings, and it can only be cured by a rejection of these proceedings. So let me just highlight what the courts have said regarding timelines. I know our documentations were rejected, so I'll just read into the answer what the Supreme Court said concerning timelines. In the Raila Odinga, under Section 60 of the Evidence Act, courts of law are usually required to take judicial notice of the existence of decisions, of judgments and all that. So we submit that a similar comparison can be taken in this House, because it's a quasi-judicial process, that the House can take judicial notice, parliamentary notice of the existence of Raila Odinga versus Independent Electoral and Boundaries Commission, and others, 2013 EKLR, where the Supreme Court, the highest court in this country in terms of the doctrine of judicial president, and therefore its decisions are binding, says, in respect to compliance with timelines, as a matter at paragraph 29, as a matter of fact, if the timelines amount to a procedural technicality, then it is a constitutionally mandated technicality. So we can borrow the same submissions here. If compliance with Section 33, which derives its authority from Article 181, paragraph 2 of the Constitution, creates a technicality in terms of procedure, then you are bound by it. You cannot change it. As I said, there's only one way in which you can change it when you are sitting as Parliament, through an amendment of legislation to provide for other timelines. So, Mr. Speaker, sir, we are really emphasizing that issue because it's at the core of this impeachment proceedings. So, Mr. Speaker, sir, we are submitting in summary that there's a serious and egregious breach of Section 33 of the County Government Act, occasioned by an official act of the Speaker in convening the House after 28 days after the statutory timelines which have been set. And just like a court of law, you then have powers to correct that mistake by ruling that indeed you have no jurisdiction to look at this issue, to look at the impeachment allegations against the governor, and proceed to make a decision accordingly. And the decision, Mr. Speaker, sir, that we are seeking is a decision to reject the impeachment against the governor and determine that the charges have not been substantiated. Mr. Speaker, sir, on the second issue, there's an additional issue there, Mr. Speaker, sir, which we can emphasize now in terms of summary. Mr. Speaker, sir, the impeachment is a quasi-judicial process. And Mr. Speaker, sir, in view of that, there's a legal question which arises again in these proceedings. The legal question is, can the governor be subjected to impeachment proceedings based on matters which are sub judice? Mr. Speaker, sir, from the proceedings of the County Assembly, a legal question now has arisen. If you listen carefully to the submissions which were made by the County Assembly, it is clear that there are certain matters which are which are being conversed in a court of law. And therefore, Mr. Speaker, sir, Standing Order number 98, your own rules of this, the rules of this House, prohibit discussion on matters which are sub judice. And the legal implication is that if you proceed to make a determination on that matter, you will be breaching that principle of sub judice, which is covered in your own standing orders. So we submit that you need to show some deference. Any matter which is you are being called upon to make a decision on, if you find that they are in the proceedings which are in a court of law, we submit that you need to apply your rational mind, apply that rational basis test when you are deciding, not to look at that matter, because it will open up a Pandora box then of saying that you have breached the standing orders. Courts are prohibited also from looking at matters which are pending in Parliament. So in similar vein, then Parliament is prohibited from looking at matters which are pending in court. Mr. Speaker, sir, the political question doctrine, any matter which covers the ambit of a political process, the so-called political questions, are matters which this House can conveniently handle. An impeachment proceeding being a quasi-judicial proceedings, then proceeds on the basis that those questions can then be addressed so long as they are not pending in court. And if they are pending in court, it will heavily prejudice. It is like subjecting the governor to two processes. One, an impeachment proceedings, which is really quasi-judicial proceeding, and then the other one is a court process, which then undermines the rule of law. As I submit, there are also policy reasons why rule number 98 exists in the standing orders. Again, rule number 98 is meant to, again, lay basis for consistency in decision making, so that there is harmonious workings of the different arms of government. And therefore, the governor has a legitimate expectation that those matters which are in court then should not be considered here because they will heavily prejudice the governor. And when you're examining this question, I invite the House to look at the evidence which has been tendered by the County Assembly and the charge which the governor faces. Because that then will clear the issue in that perspective for determination by this court, so that we don't expose the governor to what is called a double jeopardy, subjecting him to two processes, and therefore it becomes extremely and highly prejudicial.